Section 15, More on Foreclosures in California. Unit 1, California Foreclosure Basics. Unit 2, Foreclosure Procedures in California. Alternatives to foreclosure in California. Deed in lieu of foreclosure. Borrower surrenders deed to the lender. Does not eliminate junior liens, as foreclosure would. Reinstatement or redemption. Borrower pays all amounts owed, possibly entire loan amount. Must occur before sheriff's or trustee's sale. Short sale. Borrower sells property for less than loan balance plus closing costs. Lender must approve. Loan modification. Borrower works with lender to restructure or modify the terms of their mortgage so they can continue to make payments. Lender will verify borrower's ability to meet any changes to the terms of the loan. Bankruptcy. Borrower goes through legal process to discharge or restructure their debts. Chapter 7 or Chapter 13 bankruptcy filings are most commonly used by individuals. California deficiency judgments and rules. If, at the end of the judicial foreclosure process, the foreclosure sale fails to generate the funds needed to pay off the balance owed on the property, plus the costs of the foreclosure sale, the lender may be able to seek a deficiency judgment and pursue the borrower to obtain funds to make up for the deficiency. When a foreclosure sale doesn't pay off a borrower's debt, lenders will want to obtain the difference from the borrower. Certain types of loans have anti-deficiency protections. In January 2013, California redefined these loans as purchase money loans. The definition includes 1 to 4 unit residential dwellings, occupied entirely or partly by the purchaser, which were financed using a deed of trust or mortgage to secure the loan. If a loan fits this definition, the borrower is protected from a deficiency judgment. What loans provide anti-deficiency protections? When the above criteria are met, the following may be considered a purchase money loan that carries anti-deficiency protections. First mortgages effective on or after January 1, 2013. Second mortgages effective on or after January 1, 2013. Loan used to refinance a purchase money loan, such as a first or second mortgage, effective on or after January 1, 2013. What loans don't provide anti-deficiency protections? Loans that aren't considered purchase money loans don't provide deficiency judgment protections. These may include, but aren't limited to, loans to purchase a property for investment purposes, or for income production. Loans obtained from a third party, i.e., not a traditional lender, such as seller financing. Loans used to buy commercial properties. Loans used to buy land. Loans used to refinance or refinance, for example, a borrower refinanced his mortgage in 2007. He refinanced again in 2015. This second refinance does not have protection against deficiency judgments. Why? The second refinance pays off the first refinance. The first refinance is not considered a purchase money loan. Therefore, the second refinance isn't protected from a deficiency judgment. California foreclosure methods. Facts. Judicial. Used when security instrument does not contain a power of sale clause. Less common with residential properties with 1 to 4 units. Involves court action. More expensive to pursue than non-judicial foreclosures. Tends to take longer than non-judicial foreclosures. Deficiency judgment may be sought. Non-judicial. More common in California. Used when security instrument contains a power of sale clause. No court action. Deficiency judgment may not be sought. Process. Judicial. Complaint and notice of action is filed. Summons served to all parties. Lender's attorney seeks a court order to foreclose. Court orders that property may be sold. Property is advertised and a sheriff's sale, auction, is held. Property is sold to the highest bidder. Application for deficiency judgment, if a deficiency judgment is being pursued, must be filed with the court within 3 months of the sheriff's sale. Non-judicial. Mortgage servicer contacts borrower when default occurs and offers foreclosure alternatives. After at least a state-mandated 30-day waiting period, the Federal Consumer Financial Protection Bureau mandates a 120-day waiting period. The lender or trustee records notice of default with county clerk. At least 3 months after the notice of default is recorded, a notice of sale can be published. At least 20 days after the notice of sale is provided, the property can be sold at a trustee's sale, auction. Property sold to highest bidder. In some cases, lenders pursue a deficiency judgment when the proceeds from the sheriff's sale are not enough to pay off the borrower's debt. The lender may go after the borrower for the amount owed that is not covered by the sale. Generally, loans obtained to purchase a 1 to 4 unit residential property after California laws went into effect on January 1, 2013 are protected from a deficiency judgment. However, refinance loans used to pay off a loan that originated before January 1, 2013 are not protected from a deficiency judgment. Preventing foreclosure abuses in California. Often, a distressed homeowner will bring out the wolves and scrupulous con artists who prey on desperate people looking for answers. To combat this trend, there are several laws in place to protect homeowners facing foreclosure. Mortgage Foreclosure Consultant Law. Created in response to the 2007 financial crisis and enacted in 2009, this law places specific rules on foreclosure consultants. A foreclosure consultant is any person who receives compensation in exchange for any of the following activities: stopping or postponing a foreclosure sale, obtaining a forbearance from a lender, beneficiary, or mortgagee, helping a homeowner with a right of reinstatement or obtaining an extension on this right, obtaining a waiver of the promissory note's acceleration clause, which makes the entire debt be due immediately, helping the homeowner obtain a loan of advance of funds, helping avoid or lessen the impact of a foreclosure to the homeowner's credit, saving the homeowner's property from foreclosure, helping the homeowner obtain extra money from the foreclosure sale after all liens are paid. Certain individuals are excluded from the definition of foreclosure consultant, including real estate licensees performing real estate brokerage services under a listing agreement. When it does apply, however, the law requires foreclosure consultants to enter into a foreclosure consultant service agreement, which is a formal, written contract, with the homeowner. The contract must be written in clear, understandable language, and it must disclose, among other things, the services the consultant will provide, and the terms and amount of money the consultant will be paid for the services. Obviously, putting the agreement in writing will help to avoid confusion about what was promised, but a major benefit to a written contract is that it gives the homeowners something to review with their attorney, and it makes it easier for authorities to find and charge violators. Homeowners can sue a consultant who violates this law for damages and legal fees. Punitive damages of up to 3 times the actual damages incurred may be awarded in severe cases. A violation of the mortgage foreclosures consultant law is a crime, so the consultant could face 1 year in prison, fines up to $10,000, or both. California Foreclosure Reduction Act. Even lenders are required to abide by new foreclosure laws. Effective 2013, this act places certain requirements on mortgage service providers, primarily those that had foreclosed on a certain number of properties in the preceding year, including prohibiting the servicer from beginning or continuing foreclosure proceedings if the borrower has a pending loan modification request, providing a borrower who requested a foreclosure prevention alternative with a single point of contact, providing written acknowledgement of the receipt of a loan modification application, and providing written notice if the application was denied, adhering to specific date requirements for when foreclosure-related activities can take place. Essentially, this act requires mortgage servicers to provide more written acknowledgement and notice of activities related to foreclosure. It also prevents the servicer from moving forward with a foreclosure if the borrower is actively pursuing an alternative.